and someone who will also record. Anyone, please? Nani atanisaidia? Okay, someone has said that they are recording. Then Orina is sharing. Who is recording? Maybe you can unmute.
I am recording.
Who is that?
This is Pius Oyo.
Okay, Oyo. Thank you for that. Then Orina is sharing. That is also good. Thank you both. So now this is what we will do. I would like to hear something from you. If someone has an issue somewhere in preparation of exams, a question or maybe a guidance on something, we are remaining with like about 3 members to join, then we begin. Anyone who has a question that is not related to a paper preparations. And before I forget, by the way, congratulations. That is on your oral examinations results. Like I said before, your cohort is really, really bright, and I believe you guys did exceptionally well. So it is really, really motivating. So congratulations, and it gives us energy to do like what we are doing right now. I might have chosen to do something else, but if people are really committed, results are coming. So you don't worry. So even if you did not do well in orals, all is not lost. I know people, one got a 6, another a 10, another 11. They ended up actually getting 9 Ps. Okay. The difference is that if you have done really well in your orals and project work, it really makes you easier that when it now comes to the bar exams. But the other one will have to study. So some people used to tell us that if you have your orals project work in your period of preparing for exams, just assume that you have nothing. So you are working out of 60. So the fundamental question is, how many marks are you going to get out of this 60? Okay. But now on the day of exams, there's something we say 50 minus x, or is it 60 minus x? And then the x is what you are going to add there. You just use your calculator. So for some, you just only need like 2 questions and you are done. So for me, most of the time, I only needed like to answer 2 questions to the best of my ability, and that was all. Okay. So I really hope that there will be many of you who will not distress up, because you don't need to get like 100% or 90. There are people who really want that 90 or to be best student. So those ones, they will get those 90s, but sometimes a pass is a pass. If you look at your final transcript at the end of the day, it is just P, 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 P. Okay? There is no like GUI 50 or 51. So it is only on your provisional transcript. That is where you have your 50. Whereby you now have your 50, but on your final transcript, it is P, 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 P. Okay? So if someone asks a question, now any question, this is the time. We are about to go down to work. Anyone, please, quickly? Anyone? All right. Sawa sawa. I will call upon Haji Saliha. She was the first person, or is it he or she, who was the first person to join us. So please read for us question 1.
David Cleveland and Isaac Joseph are both advocates of the High Court of Kenya. David acted for the purchaser and Isaac acted for the vendor in a land sale transaction. David conducted due diligence, and after being satisfied about the status of the parcel of land, the parties signed a sale agreement. The purchaser paid a sum of 100 million shillings out of the agreed purchase price. A transfer was prepared and registered in favor of the purchaser. It was a term of the agreement that the balance of the purchase price would be paid upon the purchaser taking possession of the land. When the purchaser attempted to take possession, his entry was resisted by a person claiming ownership of the property. The parties exchanged several correspondences, but the matter was not resolved. Having realized that he would not be able to take possession, the purchaser filed a complaint at the advocates' disciplinary tribunal against the two advocates involved in the transaction, praying that they both be found guilty of professional misconduct for negligence and fraudulent conduct, withholding a sum of 100 million shillings paid through the purchaser's advocate and breach of trust. The matter came up for plea on 12 April 2021, and the tribunal recorded a plea of not guilty in the absence of the two respondent advocates. Subsequently, the matter came up for hearing several occasions, but the complainant and his advocate, newly appointed to represent him at the tribunal, were always absent. The two respondent advocates applied that the matter be heard by way of viva voce evidence so that they can cross-examine the complainant. The tribunal ordered that the issue of a viva voce evidence shall be determined when the complainant or his advocate appears before the tribunal. When the matter came up for hearing on 15th July 2021, the tribunal ignored its earlier order on the viva voce hearing and instead directed that the cause proceeds on the basis of the filed affidavits before setting down the date of delivery of judgment. On 21st October 2021, when the matter came up for judgment, instead of delivering its decision, the tribunal read a notice to produce better and further particulars to the two respondent advocates, requiring each of them to supply the tribunal with certain particulars within 14 days thereof. The vendor's advocate, whose address is PO Box 12478, Nairobi, contends that the tribunal's decision and proceedings violates his rights protected by Articles 10, 47, Articles 51, Subarticle 1, and Article 50, Subarticle 2K of the Constitution of Kenya 2010, and intends to seek legal redress. The tribunal's address is PO Box 19877, 0200 Nairobi. You are a pupil in the firm of Chemsha Bongo LLP, PO Box Nairobi, telephone that. Email chemshabongo@gmail.com. You have been requested to study the above facts, taking further instructions from the vendor's advocate and draft pleadings to be filed in court. Question A. Write a legal opinion on the legal issues raised by the facts. B. Draft appropriate pleadings for filing in court.
Okay, thank you so much, Aji. This is now where all of us comes in, because we need to now decipher this particular question. We understand what is required of us to do. That is, let's say for the first question, we are required to give a legal opinion, and then the second one will be required to prepare appropriate pleadings. So maybe now I can have a few of you. You can just raise your hand as you try to attempt question number 1A. We do it chap chap. Anyone, please? Inueni mkono. Come on, guys. We are revising. Thank you, Oyo. Take it away. Proceed.
So thank you, Aaron. So what I would say is that the vendor, the advocate has been aggrieved, and he feels that his right to fair administrative action has been violated, and he is having remedies in law. So under Fair Administrative Action Act, and he can approach the court through judicial review. That is just my thinking about the opinion I would give. Thank you.
Thank you, Oyo. So now assume you are actually drafting a legal opinion. Please tell me, how would you draft this particular legal opinion? Give me the structure. Like I said last time, the structure is really fundamental because there are marks there. For example, now this legal opinion, you have been asked to the marks awarded is actually 5 marks. So the structure of the opinion will take half, and then the other half will now go into the content. What
So
these issues? Yes.
So I would start by, of course, writing it in terms of a letter. No, not a letter, but I would start by giving brief facts. Then I'll talk about the issues arising from the facts. One being aggrieved by the. Can I just see the facts up there? Sorry, so that I decipher the issues properly. So I would, the first issue here is the advocate is aggrieved by the tribunal. That is the first issue that I see. Then I would proceed to give an opinion on the issue in terms of the law applicable. And then I would give the options that the advocate has. So Aaron, back to you, or any other person can add.
Yeah, it is Angelo.
Sorry, Angelo.
Yes. Okay, thank you, Bwana Oyo. May I please have someone else? Let us see what does this particular question needs. You have really answered well, Bwana Oyo. Let us hear what George Otieno has to say. George Otieno, proceed, sir.
Okay, good evening. Since the question is in need of the legal opinion, there are two types. There are two ways you can approach it. One is through a letter, and the other one is through a memo. But memo, we were told mostly it applies when it is within the organization. So the appropriate one is the letter. So you must start with the head or the caption, that is from, and the person you are addressing, then the reference number, then either dear sir, dear madam, in that order. Then read the legal opinion, what you intend to advise them. Then you come to the body. You must give the background facts of the matter. Then applicable law in the matter. Then analysis. After that, you in each analysis you give a conclusion. Then after that, there is a general conclusion, the advice that you intend to give that person. And in doing the analysis, you can use the case laws. That is what I can say. Then you sign off. Thank you.
Okay, thank you so much. That was a nice attempt. It was a great attempt. So the next person is Odhiambo. Odhiambo, you can unmute and proceed.
Okay. Good morning. Good evening, Angelo.
Good evening.
Yeah. I want to agree with the Mr. Oyo and the previous speaker. And because of maybe if I was doing this paper, I will take cognizance of time. I will have some brief facts, and then I will go to the rule of law. Bearing in mind is that I'm using it. I'm using the letter format. Then after the rule of law, the issues arising, and for me, from the reading of the question, I came up with two issues, but you will correct me whether they are right or wrong. My first issue will be whether this vendor's advocate's right to hearing was violated, and my second issue was whether the tribunal failed to follow the procedure as provided under maybe Article 47. Then I will now proceed to do the analysis. During the analysis, I will talk about the provisions of the statute, articles, and case laws. And then I will give my answer in each analysis. Then finally, my last paragraph will now be the general conclusion, marrying the two analysis, then coming up with the final advice to this vendor's advocate on the way forward. Then I will now sign and write my name, sign off and write my name down there. So that's how I would go about the first question. Yeah. Thank you.
Okay, thank you, Odhiambo. I however have a question because I'm really intrigued and I really want to know what is this advice that you are going to give these two advocates? Because in terms of structure, I don't know, the three speakers, they are shying away from saying the word FIRAC. Eh? Even when you are doing your exam, you just write it somewhere, FIRAC. This is how I'm going to approach it. The structure, I have no problem. That is still okay. I agree with you in terms of issues. And sometimes, by the way, if you want to answer this thing perfectly, just look at the marks allocated. This is the 5 marks question. Okay? How many issues do you need for this particular 5 marks? And you have said correctly the aspect of time factor. Okay? I agree with your first issue. I, however, don't agree on the aspect of the procedure.
Angelo, if you're speaking, you're on mute.
All right. I'm sorry about that. So now, yeah, on the aspect of the procedure, of course, they haven't followed the procedure. It is still okay. I'm not saying it is not. But you look at the marks allocation, that is fine. But now proceed and tell us, how are you going to advise these particular two advocates? What is this advice you will give them? Because it will lead us to how the pleadings that we are going to draft. Yes, Oyo?
Yes, the advice I would give is that this being an administrative body, they have a right to fair administrative action under Article 47 of the Constitution, and therefore they have a recourse in law under Article 23 for judicial review. They also have a recourse in civil litigation under Order 53 rule and under Order 53 on judicial review. They also and there is a way they can approach the court, and the procedure is well elucidated under Order 53, where they will need to seek leave and that is, if they decide to go with Order 53, they'll need to seek leave and give a statutory declaration and support it with an affidavit. Then once they are given leave, they would, of course, approach the court again through a notice of motion. The other way is they can also approach the court through a matter of right, where they can approach the court through a constitutional petition. So those are the options I would give. Under Article 23, they can approach the court as a matter of right. Thank you.
Okay, thank you, Oyo, for your views. Odhiambo, you can proceed. You can unmute.
I think Oyo has just brought it out how I was thinking now on the first issue, but now that you aren't agreeing with me fully on the second issue, I will now ask you to at least get another person so that we get to know either if there's any other different issue or if that issue can be put in a way that it comes out clearly so that we make a conclusion on it. Yeah.
Okay, thank you so much.
Welcome.
May I please have someone else, maybe before I proceed? Anyone else, please? Anyona Oscar, yes, you can unmute.
Sorry, I would have really liked to make my point, but as you can hear, I'm still settling. So allow me to take some time and then I'll be back. Sorry.
Oh, okay, very well. Yes. Okay, so guys, it is pretty straightforward in the sense that it is a legal opinion, like I told you before. Structure is equally important because they do mark that one. There are marks for everything. There are also marks for the content. So, and you would agree with me that the tribunal in this regard, they did not conduct themselves well. Okay. So actually, I would come up with just a single issue for determination, whether their right to fair hearing was actually violated. I would come up with that particular single issue. Okay. So, and just like for someone, you can just tell us, for example, Article 52 or Article 47, or those articles that have been highlighted. What does they say? Okay. So you realize the single issue for determination here, or the single issue that you would like to advise them on, it is whether they actually have a recourse in terms of their right to fair hearing. Because in the first instance, by the way, a plea cannot be taken when an accused person is not present. And by the way, I have a question. How are charges preferred or taken before the Advocates Disciplinary Tribunal? I understand, for example, in the Magistrate Court, we have charge sheet. In the High Court, we have information. What about the Advocates Disciplinary Tribunal? What do we use? Anyone? Quick answer. charges before advocacy disciplinary tribunal. Tunatumianga nini? What do we use? There's a charge, there is information. What do we use? Anyone? Yes, come on, guys. Anyone? Okay, no one. Okay, so I would come up with that simple.
Statement of charge.
Huh? Who is that?
Is it a statement of charge? David Jeru.
David, you are saying, is it?
Just inquiring whether, because it's not a charge sheet, really, is it a statement of charge?
No, it is not. But thank you for the attempt. I hope maybe someone has come from the state law office. They always give that particular lecture. That is Advocates Complaints Commission, Advocates Disciplinary Tribunal, or Disciplinary Committee. Okay, so you will see that the trial before the tribunal, it was met with a lot of improprieties. At one point they say this, on the other point they say the other. Okay, so for me I would come up with that single issue, and noting that it is 5 months, for me I would think that it would suffice, okay, or suffice. So that is on me, that is with me, FIRACT, and the issue would be we interrogate the aspect of fair hearing. Anyone with a question before we go to part B? All right, guys, muchangamke bana. This is a discussion. Anything you say, all the answers are correct. All right, let us now proceed to paragraph B. Oh, sorry, question number B. Draft appropriate pleadings for filing in court 15 months. I have Oyo's hand up, but may I hear from someone else, please?
Mine is a question.
Okay.
You've not commented on the advice, if we were correct in your view.
Yeah. On the advice, you see, this is a legal opinion. So all the answers are usually correct. Okay, you can actually advise him on those two routes. They can go by way of constitutional petition or by way of the traditional judicial review. Okay, so either way, for me, the answer on the advice, it was correct. But the question
Thank you.
Is it correct on part B now? Someone has given the answer on the chat. Yeah, it is an affidavit, okay? It is an affidavit. Yes, someone just raised their hand and they disappear. Please proceed, address us on question number B. Odhiambo, you have something to say, or you want to answer question number B?
First, what about the affidavit? I've heard you talking about affidavit.
It is how charges are brought at the Advocates Disciplinary Tribunal.
Okay. Now, just an attempt again in question B, because I think if we came up with the correct issue in question A, then that issue would now guide us to know what to, how now these advocates can approach the court. And for me, there are two ways. They can approach the court through judicial review or through petition. And personally, if I was sitting for this paper, I will take the route for petition because, again, because of the time, judicial review will require me to draft all the stages. Is it 5 or 6? The leave stage, again, the substantive stage. If you compare that with the petition, at least petition, you can draft just one document, then you support, you draft a supporting affidavit. So I would do a petition, and
You are muted. Margaret, proceed. Thank you, Odhiambo.
Okay, for me, for question B, I would have drafted chamber summons, a statutory statement, and a verifying affidavit, based on the fact that for judicial review applications, when you look at Order 53 Rule 1 of the Civil Procedure Rules, it provides that when matters to do with judicial review, the first thing that you should do is that you seek leave from the court, and you do that through chamber summons, together with a statutory statement and a verifying affidavit. So once the leave has been granted is when you'll now file a notice of motion and a statutory statement and a verifying affidavit. So for me, how I would have approached the question is through drafting the chamber summon, statutory statement, and the verifying affidavit.
Okay, thank you. Thank you, Margaret, for that answer. Stephen, your hand is up again. Odhiambo?
Yes.
Okay, guys, we have heard from two people. One person is saying constitutional petition. The other person is saying JR, judicial review application. Okay. Do we have another person, either in support of one or the other? Please, guys, all the answers are correct. Honorable Jacob Were, please proceed.
Yes. Good evening. How are you, Angelo?
I'm fine, thank you.
Now, yes, thank you. Now, my question is, I'm in support of both of them, but my question is, if I go through the chamber summons way, then at no time will you ever be found to be drafting all of them at the same time. So either you're at the leave stage or you're at the substantive stage. So in this case, am I allowed to maybe draft chamber summons? I put statutory statement, I put in there the supporting affidavit, and then I leave it at that stage.
Yeah, maybe you just need to correct a little. There's something you have said, supporting affidavit. It is not supposed to be that one. Which one?
Verifying for chamber summons is verifying thing. So yes. My mind was on the notice of motion. Now my question is, because at no time, whether in practice or otherwise, will you be drafting all of them at the same time? You usually draft one, and then when the leave is granted is when you draft the other one. So in this case, maybe can they allow me to draft one, like chamber summons, then I put down their supporting notes. I don't know.
You see, okay, that's a good question. However, you see, in JR, you have to seek leave first, and after, if the leave is granted, then now you file your substantive motion or your substantive JR application. Okay. So most of the time they ask you to advise, because it is really a lot of documents that you are required to draft. Okay. So most of the time you will just advise someone on the procedure, but you will not actually draft a JR application. But if you are required to draft, then you will have to draft the leave stage. Then after, you proceed and draft your substantive motion or your substantive JR by filing the notice of motion. But you have to remember Order 53, the way it is, if you have been told by some lecturers, well, they do say that you file a supporting affidavit. But that is not the case as per Order 53. You don't file a supporting affidavit. But if need be, you can attach that particular verifying affidavit, that you can attach copies. That is what the law says. Okay. Let me see what Orina has to say. Orina?
Thank you for the time. Mine will be to this last paragraphs of this question. It says that the vendor's advocate whose address is that contends that the tribunal's decision in the proceedings violated his rights under Article those ones of the Constitution. So my attention has been drawn to what redress is my client intending to seek. So he intends to seek legal redress. So for me, I'll proceed with a petition because I've already been given the constitutional provisions that have been violated. So with that, I'll proceed with a petition to seek the legal redress. I'll not go with JR because of the procedures involved in JR and the limited remedies therein. Thank you.
Okay. Thank you, Orina. That was actually what I was looking for, because two things here are going to show you how are you going to approach this particular question. Okay. The first one being those particular constitutional provisions that have been cited there. And you see it is very clear. You have been given content that the tribunal's decision and proceedings violate his rights protected by Articles 10, 47, 51, and 52 of the Constitution of Kenya, 2010, and intends to seek legal redress. Okay. Then if you move, Jero, I'm coming to you. Now go down, our tech expert, senior cyber attendant. Yes. Enda chini kidogo. Yes. Thank you. Former cyber attendant. So now you see that you have been told that draft appropriate pleadings for filing in court. Keyword being pleadings. You see, judicial review is an application. Okay? Judicial review is an application. Okay? Judicial review is an application. Okay? You have been told to draft appropriate pleadings. So two things we are going to show you the way to go. Okay? Let me hear what Jero has to say. Jero, please proceed.
Thank you. Actually, I just wanted to amplify what the previous speaker said, because if you look at the way the question is framed, we have not been told in any way that the tribunal had reached a decision, other than that, although the question is not clear, maybe if someone can share the question paper on the group, but from what I'm able to see here, is that the tribunal gave directions that hearing shall be via viva voce if all the parties are present, meaning there was no decision that the tribunal had made that would warrant a judicial review in terms of an application, so that to have it, to have it quashed or maybe revoked or reviewed by the court, but rather the client, the one we are advising is merely seeking protection of his rights or violation of the same as per the provisions of the Constitution as he has alluded or we have been guided. Therefore, I am in agreement with what you have said and with what the previous speaker said, that a petition would be the most appropriate pleading to use for this particular case. I just wanted to support that. Thank you.
Thank you. I have two people who are saying that someone is trying to remove them. So please, you proceed and speak, if just in case something like that happens. But I appreciate how you are looking at it, because in any event, there is no actual any decision that you require those three prerogative orders. Okay, by the way, now they are entrenched in the Constitution. They are no longer prerogative orders. Article 23. Okay, so they are no longer that one. But it is safe we just say it like that. Okay. So can someone maybe tell us what these orders do we seek at judicial review? Barak, I will come to you. Barak, you can just speak up. What are these three orders that you seek in a traditional JR?
Certiorari.
Okay, someone is mentioned.
Yes, Madam President. Proceed.
Certiorari, prohibition, and mandamus.
Okay. Mandamus, mandamus, certiorari, prohibition. They are all of those are orders of the High Court. Okay. So Barak, you raise your hand. Let me hear what you have to say.
Yes, definitely. This is an area we've ventilated before by a few members here. The question of whether we should go the JR way or the petition. I would agree, and I've not changed my position that given it's an exam scenario, it's perhaps easier to adopt the petition way. However, in the course of study, you get a few views that tend to bring a little bit of confusion because there is this principle of constitutional avoidance such that where there is an alternative remedy, where there is remedy, then you are discouraged from pursuing a constitutional petition to enforce a right. You find this being repeated over and over, such that it's become very fatal to go for a constitutional petition on a question of right, where remedy lies in another procedure. You find that being emphasized in Abraham Kaisha Kanzika against CBK governor, the quoted Communications Commission of Kenya and others against Royal Media Services. You'd find that also coming out in Patrick Mbau Karanja and Kenyatta University. So the thing coming out is that if there is another procedure provided for or a remedy lying somewhere, then you don't go the constitutional petition way. I don't know how that works now in an exam situation. I would think that if I was doing it practically, maybe, then this would apply, this constitutional avoidance. I don't know whether we can be given some room in an exam because this seems to be the principle now.
Okay, thank you for your contribution. However, the doctrine of constitutional avoidance is an intricate one. Okay, and most of the time you see these prerogative orders and constitutional petition, we call them public law remedies. So when you want to apply the doctrine of constitutional avoidance, is there any remedy that is there in private law? Okay, but then if you are going for judicial review, what you are seeking are public law remedies. By way of constitutional petition, public law remedies. Therefore, the doctrine of constitutional avoidance, I don't think per se it applies in judicial review, but it applies in other matters whereby there is another remedy that is provided for in law, such that now you don't invoke constitutional court jurisdiction if you have, let's say, a remedy in contract. You can just go to the High Court commercial tax, okay? But for this, I don't think it is, if there is another remedy that is there in law, then this is whereby the doctrine of constitutional avoidance will apply. But in this regard, we will not go to it that way. In an examination, and I told you guys last time, and I remember what is her name. I have forgotten her name when she tried to see if they can seek extension of time. CLE by they are always straightforward. See where the question is. Umeulizwa aje. Okay? Like this one, you have been given constitutional provisions. Then Apple, they have gone again telling you pleadings. But what is there? For example, those who did these exams, there are those who did JR, they got marks. Those who did constitutional petitions, they got marks. But the disparity was who got the highest marks. Okay, so either those who went the constitutional petition route, they scored highly. Those who went JR, because you can use JR, okay, even when I was doing my revision a few months ago, okay, actually many months ago, my first attempt was that I actually used JR. Then a certain wise lady, she said, you know what, Makwelo, actually, we are just, this one, it is a constitutional petition. And she explained why. So, and there is our lecturer for legal writing and drafting always say, just look at the question. What are they asking? Such that now, hiyo ingine inakuwa story ya Java, ama ni Mogoka, and then now we come to the other one, okay? Madam President.
So just to add on, we were told that judicial review should not be the first instance you think of. You should first exhaust. We do the doctrine of exhaustion, and then again, the orders that you can seek in judicial review. When you do a constitutional petition, I think you can also, and I think, just a moment, the issue of timing here. So when you do judicial review, I think it's going to be time barred, but with a constitutional petition, it's safer because you can still seek judicial review in that constitutional petition.
I agree. And thank you for that. As Jura Justus is about to unmute, when you are raising your hand and for whatever reason you are unable to raise your hand, then you can always proceed and speak. Jura Justus, then Onyango, then we'll move on.
Okay, thank you very much. This is the input I have on this particular question. I don't think looking at the issue of time would be the appropriate way to disregard the judicial review, but I think there are other parameters that we need to consider so that we know whether the constitutional petition that is facing the case. So for me, I'll be guided by the constitutional provisions that are already provided in the question. Number two, I'll be a bit preemptive in terms of orders that I intend to ask the court to grant. And the orders that we're talking about, mandamus, certiorari, and prohibition, some of them are dependent on a decision that is already made that you are impugning, whereas some are actually impugning a procedure or compelling a statutory body to produce certain document and present before court for possible review where necessary. So if I go that route, I would be a bit in more of an ambiguous position to come up with those orders under JR. But I find it easy where I'll be now having a wider latitude to frame my orders the way I want them under constitutional petition. So it is on that account that for me, I would go with the constitutional petition. Thank you.
Okay, thank you, Jura. Onyango?
Okay, thank you. Mine just simple because based on the analysis, constitutional petition suffice. But my question is the court to approach, because this matter involves the land issues. Are we going to High Court or environmental law, environmental court?
That is a very good question. We did not actually thought beyond that, but this one will go to the High Court, Constitutional and Human Rights Division. Okay, so it is the question here. It is not the subject matter or what led to it. It is the conduct of that particular tribunal. Okay, so you will not sue that tribunal at the ELC. You will sue it and in the High Court. That is the Constitutional and Human Rights Division. Okay.
Thank you. Thank you.
All right. Where Jacobs?
Oh, I wanted to ask the same question, but thank you. I've now gotten it.
Okay, okay. Thank you very much. So, guys, I understand we have said constitutional petition, we have said JR, but maybe just let's say in under 5 minutes. I understand we have spent a lot of time here. How do we draft this constitutional petition? And Mark, maybe this time round, I pray to God we do not actually draft any constitutional petition. I don't know how you will pray to your God, okay? Ours, Mungu alicheza kama yeye, it was just a mere playing. How is your God going to play? That is the fundamental question. So how do we draft this particular constitutional petition? It is one thing to say constitutional petition, but what should be included? You see, someone was saying, if we are going JR, certificate of urgency, chamber summons application, statutory statement, we finish with, let's say, verifying affidavit, and if it is substantive JR, I use a notice of motion application. That is enough. Can someone now tell us, what about the constitutional petition? How do we go about it? What do we draft? And the reason I'm asking this, because I'm really hoping that someone has read that constitutional petition of Okiya Omtatah. And that should be your guide, by the way. Okay? And in your legislative drafting, use the latest version. There are a lot of bills now in Parliament. Just go to your Kenya electronic law reports and download one. If it is amendment, just do it. Okay? So guys, anyone, how do we go about this particular constitutional petition? We know the caption, we know what your humble petitioner. I don't know, someone please, in under 5 minutes, because we need to go to question 2. My learned friends. Anyone? Okay. And that is your exercise. Huh? Okay, Oscar, in under 5 minutes, please.
So, thank you. So I'll come in at this place. And because we made reference to the Omtatah petition, so in that petition, but before I go there, if you look at the Mutunga rules on how a petition should be drafted, it's very basic. You only as the parties, and then the legal foundation of the petition, the facts are relied upon, and I think after that you go to the relief sort. But if you go to that Okiya Omtatah petition, he has parties as the first part of that petition, where you describe the names and addresses of both parties or parties in that petition. Then he has the locus standi, then jurisdiction of court. Yes, and then the next thing he has in that petition is the legal foundation of that petition. And under that part, he states the articles of the Constitution that have been not violated, but under which the petition is premised, and then facts upon which he relies on. And then after the facts, he talks about the nature of the main violations or threats to the Constitution of Kenya. And then the last thing, I think the last thing, at the relief sought, the reliefs and prayers sought from the court. So, but I think for the purpose of exams, you may want to exclude some of the things like locus standi and jurisdiction of court so that you save on time. So then, if it were me, I would say I would talk about the parties in that petition, the legal foundation thereof, the facts relied upon, the issues, sorry, the nature of the main violations, and the relief sought. Thank you.
Okay, thank you, Oscar. And anyone else? Finally? Okay, proceed, George Otieno.
Okay, George Otieno, George Onyango, all are my names. It's only that I keep changing the gadgets. So in addition to what the previous speakers said, I think you need to recognize the jurisdiction of the case. Then after that, the jurat also you must indicate the person, the jurat that is containing the details of the advocates. Then after that, I think you come up with an affidavit. An affidavit, yes.
That is a affidavit in support of the petition.
Yeah, supporting affidavit.
Yes, because the question there is appropriate pleadings, okay? So anyway, guys, Jacob, thank you, Bwana Onyango. Jacob, you have something to add? Because I want now to give you at least 5 things that you should include for purposes of CLE exams. But proceed.
Now, for me, I was saying the caption should have the constitutional petition. That should be under the caption, included in the caption. And then I was not sure whether I should use in the matter of, now that they have given me the constitution that it has been violated, maybe I can say in the matter of maybe Article 52 in this case, in the matter of Article 50, in the matter of like that. And then now between the parties, who will be the petitioner and the respondent when it comes to the parties, and then now petition, and then now I have to address it to the registrar. That was the part I thought was missing.
Okay. Thank you for that contribution. So guys, this is what you should do. Huh? You see, like the way they have the way they have listed those addresses, it was for a reason. Eh? So it was now for that purpose. Huh? Okay. So you just, the Republic of Kenya, in the High Court of Kenya at Nairobi, the constitutional petition number, this one, in the matter of, okay, you do in the matter of, for example, Article 47, that is in the matter of. So after that, now when you are done with those in the matter of violation of the Fair Administrative Action Act, so now you now proceed and give your parties, the petitioner and the respondent. Then now you go to your petition. It should be basic, eh? And you will note this one even in your exams, because you will have at least 2 drafting in civil litigation and criminal. Don't be so complicated a lot, because time is of essence. Eh? So this is what I'm suggesting. After you have now written petition, so you can say the humble petition of so and so, okay? Then you put the address of service, like that. Now your part A, now you can write it down if you have your pen. So your part A or part 1. So that one of the reason I like that one of Okiya Mtata, it is detailed, but it is exaggerated. But this is what, for purposes of our Nini right now, when we go to pupillage, we will deal with those one later. But for purposes of CLE, you can start your number A. That is A now will be the parties. Describe the parties like the way you have been given in the question. You can still pray, say that you don't get constitutional petition. Then your B is the legal foundation of the petition. It is also in the petition. It is also in the question. Okay, legal foundation of the petition. That is number B. So mine would have like 5 heads. So you will describe those particular constitutional provisions. Then you will now proceed to your number C, the facts. Okay? Because there are facts under which the petition is grounded. What are these facts? You give brief facts as per the question. Okay? Then now you proceed to your number D, that is now particulars of breach of the Constitution on the part of the respondent. So now you now give the particulars of that particular breach. Okay? So after you have talked about those particulars, now you go to what? Finally, prayer sought. That is your number E. What are these prayers sought? And how do you give your prayers in a constitutional petition? So you give in terms of declaration. A declaration that this one happened, a declaration. So your prayers are in the form of declarations. You look at Article 23. Then now you proceed now and give your jurat. I don't know if I have made it simple enough, guys. And don't forget to put an affidavit in support of the petition. Very, very important. Okay? The way you have those documents accompanying your plane, there are also documents that accompany your petition. Okay? So we have something called an affidavit in support of the petition. George.
Yes. Instead, are we limited to only say declaration that, or we can say order that? We pray for the order.
You can also give an order. The court can make an order. You are not limited to a declaration. Okay.
Fine. Thank you. Thank you.
Yeah, courts make orders. So guys, if you are all satisfied with question 1, so we can then move quickly to question number 2. Okay. So let us clap for everyone. Let us clap for everyone. Thank you so much. Thank you so much. Now let us make this 10 marks question as exciting as possible. Twende sasa kwa hii mkubwa anaitwa mapesa. So someone
and maybe before you proceed.
Yes, proceed.
Yeah. Are there at least the document that we are touching other than supporting affidavit?
To the best of my knowledge, it is the affidavit in support of the petition. I am not aware of any other document. Is that okay?
Yes, I was seeking that clarification because for a plaintiff, there are many documents that we usually accompanying documents. So I was seeking clarification whether this petition also we need to supply the same documents.
I hear you. Yeah, because sometimes you file when you are filing your petition, the one that you use like a notice of motion, or when you are under certificate of urgency, you file a notice of motion, then you file your supporting affidavit. But this one, it is just like you file your petition and then you put your affidavit in support of the petition. Anyona?
Yes, I would like to attempt a quick response. Yes, I don't know if you can hear me. Yes,
I can.
I would like to attempt a quick response to that question on whether there's any other document that you draft. Now, I've gathered from elsewhere that under the Mutunga rules, you can actually do that petition and a certificate of urgency if you consider the matters therein urgent. So I'm interested in hearing your comment on that.
Yeah. So it is if it is urgent, you know, you will need interim order. It is what even Okia Mtata did that. Okay. You have your substantive petition, but there are orders, maybe there are consultancy orders that you will seek. Okay. So you will file a certificate of urgency, your notice of motion application, that you will seek conservatory orders. Yeah, but when you are filing a petition, please file your petition, draft your petition, and an affidavit in support of that petition. Okay? So can I have someone? They unmute or raise their hand as to submit question number 2. Anyone, please?
Mapesa, a renowned businessman, has been denied an environmental impact assessment EIA license by the National Environmental Management Authority, NEMA, which he required to put up a block of apartment in Banda area of Nairobi City County. Mapesa believes that the environmental agency has made an error in denying him the license. Mapesa wants to challenge the decision and has come to you for advice. As an advocate as an advocate in law firm of Excel and Company Advocates, you agree with Mapesa that the National Environmental Management Authority has made an error in denying Mapesa the subject license because they took into consideration irrelevant facts that did not relate to the project in question. Using applicable law in Kenya, explain to Mapesa the procedure to be taken in order to expeditiously challenge the decision of the National Environmental Management Authority.
Okay, thank you so much. Sikuona jina yako. What is your name? Our reader.
Faith Mawea Benedict.
Okay, thank you so much. So now, guys, this is one of those specialized tribunals, because I believe at one point, I don't know how your syllabus is, but there are always times that we are required to talk about the specialized tribunals. So one of those tribunals that is examined a lot most of the time, it is, I don't want to say the name, but it's a tribunal relating to the environment. Okay, and it is something that is really, really sweet, and I will encourage you guys to study how do we do proceedings before that particular tribunal relating to the environment, because because here is now the question. Very, very sweet, very beautiful. Okay, but not beautiful like my 10p. But let's have someone attempt this particular question too. Okay, and anyone, please. Let me hear what you guys have to say about this particular proceeding. Mapesa has been denied EIA license by NEMA. He now wants to expeditiously challenge that particular decision because, according to him, they have considered some other factors that they shouldn't have considered. Anyone, please? 10 marks. Let's raise our hand, chap, guys. Odur Atieno, proceed.
Good evening. So from my perspective, I think this is a judicial review matter because we've been told that, okay, let's say a judicial review is whereby the High Court looks at the decisions of a public authority, public or private. So NEMA is a public body, and somewhere here we've been told that they took into consideration irrelevant facts that did not relate to the project in question. So that's one of the grounds for filing a judicial review under the Fair Administrative Actions Act, I think Section 7. So for the procedure, they'll first have to seek leave from the Oh, yeah. Now I'm looking at it in the aspect of tribunal, but for the judicial review, they'll first have to seek leave, and in seeking leave, they'll need to file the chamber summons and the affidavit and the statutory statement before they can now proceed to the High Court. Once they've been given the permission, they can now proceed to the High Court and file the judicial review, now seeking the orders that irrelevant facts were considered, and therefore he was not given that EIA report. Thank you.
Thank you, Ms. Atieno. May I have that was a great attempt. Thank you for that. I have Odhiambo and I have Were. So, and I have George, and they participated in question 1, all these 3 gentlemen. I believe there is no gentlewoman here or gentle lady. Okay, apart from the 3, anyone else, please? I have not said that you drop your hands. Please maintain your hand. Asa huyo ametoroka. Mbona unatoa mkono yako mkubwa? Very well. So let me have Gitangata, Penstan. Yeah. Hey. Okay.
Good evening.
Please, if you have raised your hand, just maintain your hand up. Sasa. Thank you, Odhiambo. Thank you, Were. Oyo, put your hand up. Oyo mwingine alikuwa nani? Please put your hand up. Yes, proceed.
So in my own thinking, at the moment I don't have the law prescribing, but I ought to think that if you're aggrieved by the decision of NEMA, you're supposed to file an appeal in the Environment and Land Court. So that is what I would suggest to the client, that we go via an appeal to the Environment and Land Court. And in case maybe they are aggrieved by the decision of that particular court, then again they have a chance to have their final appeal in the Court of Appeal. Yes.
Okay. Thank you for your attempt. That was good. Okay, Stephen Odhiambo. Proceed.
Okay. Let me just make an attempt.
Mm-hmm.
Okay. Within our syllabus, we haven't covered tribunals, but I think if you are dissatisfied with the decisions of NEMA, I think because of the doctrine of exhaustion, we are supposed to appeal to National Environment Tribunal, so that the decisions of that tribunal are what now we go to maybe Environment Court to appeal to. But with regard to how we come up with the proceedings, I am yet to cover that, and I will really appreciate if I learn that from you. Yeah.
Okay, thank you so much, Stephen. You see, people they were just clapping, wamefurahi sana. Anyway, that is very, very good. Let me see what Were Jacob has to say. Maybe you'll now take it up from where you left.
Yes, I wanted to put my hand down after that, because that's what I wanted to say. I'm not quite sure with how to approach the tribunal, but all decisions from NEMA go to ETA, to the tribunal. Yes, they don't go direct to court. They move direct from tribunal is when they move to High Court. But if we are told they're still at the NEMA, then we are supposed to move to the tribunal.
Did you just say High Court? Or that was a slip of tongue?
I said from tribunal is when we can appeal, maybe I think to ELC. At this time, Emma. Okay. I said High Court. Let me. It was ELC.
You said High Court.
Yes, I said High Court, but it's supposed to be ELC. From tribunal, it's from NEMA to tribunal, from tribunal to ELC, from ELC to Court of Appeal. Thank you.
Very good, thank you. George? Then we'll have CDS. George?
Okay. I'm of the same opinion as Jacob has said. The doctrine of exhaustion, it's from the NEMA to the tribunal, then the Court of Appeal.
Okay. CD?
I would support the first speaker, and in support of her procedure for judicial review, I will do judicial review because they have said that we want to expeditiously challenge the decision. So I will do judicial review application, and I will do it under certificate of urgency, so that to just satisfy the section of the question that says we should do it expeditiously.
That is a great contribution. Yeah. Thank you all for that contribution. And please, again, let us clap for them because they have really attempted. And I'm not going to lie to you. I don't know when your term is coming to an end. You may not even cover this area, and it is in your syllabus. So it then becomes how vigilant you will be. But most of the time, it is the National Environmental Tribunal that is tested. So you can be told, you will not be told to draft the notice of appeal itself, but you will be asked to give a procedure like in this one in question 2. Okay? Most of the time it is the NEMA, the NET, the National Environmental Tribunal. So let me first answer those who are saying that the aspect of judicial review. You see, there is a procedure that has been provided for in law, and it has to be followed, okay? That is where it is something called the doctrine of exhaustion, okay? It is called the doctrine of exhaustion. So we'll have to exhaust all those avenues that have been provided for in the statute. I'm not saying it is not wrong for you to just leave NEMA and go to ELC direct to challenge the decision of NEMA, okay? But the issue is, I have a decision of the Supreme Court somewhere. There are procedures that have been provided for in law. So these particular procedures must be followed, okay? They must be followed. So you will not escape or you skip NET. NET is an integral part of that particular procedure that has been provided for in law. So I don't know if it is the case of Karisa Chengo. Maybe it is you guys who have studied. It is actually a famous case. Okay, Karisa Chengo. So it is something you guys will Google. Maybe it talks about a lot of things, the ELC, the ELRC, the High Court, something called subject matter expertise. That is not the word that has been used. But sometimes it is not like a judge does not have jurisdiction to handle that particular matter. But due to something called subject matter expertise, then that is why it's supposed to be left to this particular body that has been provided for in law. And for me to proceed and answer this question, now that I have answered those who are saying that we are going by way of judicial review, so you first go to the National Environmental Tribunal, NET. So it can be the NEMA itself that will challenge the decision, that will appeal. Oh, no, it is the person, sorry. It is not NEMA. NEMA now will go to ELC after, let's say, their decision has been overturned. Okay? So NEMA will then will challenge the decision of the NET. Okay? So what happens is, I'm not going to give you the procedure. What I will just show you how to go about it or where to find it, because I doubt if you will be told. So you approach the National Environmental Tribunal via way of a notice of appeal. Okay, it is an appeal. That is why it is national. It is net, but you approach it by a way. It is an appeal. NEMA has made a decision. Now you appeal that particular decision. Okay. So it is by way of what? A notice of appeal. So this one, you look at it under Rule 4.1 of the National Environmental Tribunal Procedure Rules of 2003. Okay, so the procedure has been provided for clearly under those rules. Okay, especially that that Rule 4.1 of the National Environmental Tribunal Procedure Rules of 2003. Specifically, you can actually start from part 2, then you can go all the way down there such that you can know the type of document to draft. Okay, that is the way that you can go about it. So I really like this question because it challenges you. So before you sleep today, please try to attempt, just start the NEMA, the procedure. Most of the time, it is always about the procedure. Okay, I don't know if someone else has a question that they want me to answer, because you will not be told this one, so you'll make an effort. And it is always about the procedure with respect to the National Environmental Tribunal. Anyone with a question, please? Is someone trying to speak? Yes, George.
If you read the statement of facts well, I'm still struggling to, for those people who gave the answers for judicial review, because this is a decision that has been made by a body. Can you approach the court also through judicial reviews to compel that that body to issue such document that is being required by the aggrieved party?
No. So you see now in this regard, that is why I have agreed with them that it is a way, but you see how it is, the doctrine of exhaustion. So you will not go to court direct because this is within the mandate of the National Environmental Tribunal. So you will not use the judicial review in this instance. Yes, Madam President.
So I have a question. You said we use a notice of appeal. So I thought notice of appeal was supposed to be used when we are approaching court of appeal.
Yes, but this is an appeal also.
The tribunals. Okay.
Yes, this is also an appeal. It has been provided that way in law. I agree with that one, that when you are approaching the court of appeal, you use notice of appeal, or when you are appealing to the high court, you use notice of appeal. So any decision that is appeal, you use a notice of appeal.
But I thought when you're moving from, hello, you can hear me? I think you were breaking.
Yes.
So
yes, I can hear you.
When you're moving from a subordinate court to the high court, I thought we usually use a memorandum of appeal.
Oh, but you first use yes, memorandum of appeal. Yes.
Yes, and then a notice of appeal, you use it when you're moving from the high court now to the court of appeal.
Correct.
So that is why I asked that question. Are we comparing tribunals to the status maybe of the court of appeal? Maybe for clarification.
No, we are not. These are specialized proceedings. These are specialized proceedings.
Thank you, understood.
Okay.
Yes, thanks.
Yeah, so you put that one aside, so it is totally separate from this, because this one, it is statute based. Okay?
Yes, thanks.
All right. Anyone else, guys? Yes, Njeru. Then Oduor Atieno.
Yeah, thank you. I just wanted to probably support the reasoning and just point out that Section 129 of the NEMA Act provides that anybody aggrieved by the decision of the body shall appeal within 60 days to
is it 60 days? Yes, within 60 days after the occurrence to the tribunal. So the reasoning is very much in order.
Yes, and it is something that is statute based. So you just follow what the law says. Okay. So especially if you look at Rule 4, Paragraph 5, it is saying that the appellant may include in his notice of appeal. So the name of the document, it is something that has been written in law. Okay. We had another person that had raised their hand, and I would really like someone to Google those particular documents because they are about 5 or 6, because this is the easy way that you will understand it. Because the procedure that you are being tested here, you see, even those days, they are very important in your answer. I don't think you'll be told to draft, but the procedure, even those dates, the type of documents that you are filing, they are very, very important. Okay. I had someone when aliinua mkono and then they decided to disappear.
Oh, that was me.
Yeah,
so I understand. I've understood actually, and that's the position that it's not judicial review, not judicial review. Maybe to now proceed and help in answering what George had asked. Section 9 of the Fair Administrative Actions Act requires that you must first exhaust the remedies. That's the statutory basis, and then maybe under, I don't know, subsection 4, you can only now proceed and go directly to the court where you can show that there are exceptional circumstances. For example, that the tribunal will not accord you justice or something. That's when you can go directly.
Yes, there are several. Is it floriculture? Okay, I don't know case that talks about the aspect of exception. Now, what is going to make you now to skip this net and go to the High Court direct? Okay, but thank you guys. Content Mukonayo. I hope CLA will be gracious with you. Okay.
Please repeat.
Sawa.
Which section?
Pardon?
Previous speakers invoked a certain section in the Fair Administrative Action Act.
I said section 9 of the Fair Administrative Actions Act.
Okay, thank you. Very well, thank you. So, like the way you guys have noticed now, these questions were just made here in Nairobi. So there is no question that will come from anywhere else. Okay, just know your stuff and everything will be all right. So let us go to question number 3. Mwenye anaona amechangamka sana, you can just unmute and read. Mwenye amesoma hadi next year. Okay, mwenye hajasoma hadi next year.
Acha nikusome.
Nice. Aya, mwenye anasoma basi, huyo ndio senior. Soma basi, senior.
Question 3. A notice of motion dated 18th January 2021 and filed by the appellant under Section 80 and 3A of the Civil Procedure Act and Order 45 Rule 1 of the Civil Procedure Rule 6, a review of the court order issued on 25th December 2020, and that the appellant be allowed to deposit Kenya shillings 500,000 as a security in a joint interest earning bank account within 45 days. The appellant contends that she has made every effort to secure half of the decretal sum as ordered by the court, but all efforts have borne no fruit, and that the present application is filed without any unreasonable delay. The respondent opposed to the application, arguing that there is no sufficient reason given upon the order sought, and that the court in the exercise of its jurisdiction is not dependent upon what the appellant is willing to offer as security. In addition, the respondent notes that the court makes decisions based on law and not pity. The orders sought to be reviewed were pursuant to an application seeking stay of execution of a decree awarding the respondents a sum of Kenya shillings 1,800,000. In the said application, the appellant pleaded financial difficulties and sought the court's lenience. The court considered the matter raised in the application and ordered the appellant to deposit Kenya shillings 900,000 in a joint interest account operated by the parties' advocates. Draft the ruling on the issues raised as well as merits and demerits of the case. 10 marks.
We know how the ruling is going to go. So, but now let us draft this particular ruling. I don't know, do we need to read the question again? Because I think it is straightforward. Section 80, Section 3A, Order 45. The application for review seeks actually to review the orders made in a stay application. Okay. So now we have been requested. Okay, it is not a request anyway. We have been asked to draft that particular ruling on the issues raised, as well as merits and demerits of the case. 10 marks. So we will lead us in this discussion, guys. This is a great question. Stephen, go.
Okay, I really don't want to go. I want to give others a chance, but I want to ask because I just want you to clarify, because I've looked at these papers, and when they said about rulings, they talk about that you talk about the merits and demerits. So my question is, where do you now talk about these merits and demerits? Please, can you just clarify them to me? Because I've realized it's being said so much, and it normally confuses me how to go about it before we come back now to go through the ruling.
You see, I believe a ruling or a decision of the court always have consequences here and there. Okay? But sometimes it is always, what does the law say? Because here, there are things that we need to interrogate. I don't know if I'm answering your question perfectly, unless if you are talking about merits and demerits, that is in LPM. Okay? Because here
no, this is with regard to civil. This is with regard to civil. LPM.
Yeah, because you see, let's say, for example, what will be the consequence of a decision that will be rendered in review? Do you appeal the original decision? Look at the dates that have been given. Okay. The decision that is being reviewed, when was it issued? What if, let's say, a decision on review? Do you appeal the previous decision or do you appeal this particular decision? But I know this merit, there's no way you will include them in your ruling to that extent, but it is what is the position of the law as far as Order 45, Section 80 are concerned with regards to review.
Okay, thank you. I think I am now well guided.
All right, all right. Yes. Someone please to answer this question, question number 3. We are in number 3, even not number 4. We are left with about 55 minutes. We finish, eh? Anyone, please? Who is going to draft for us this ruling? We drafted another one last time, eh? So you just like, you base your you're ruling on that structure. It is just the same ruling. Okay, Njeru, David, please.
Yeah, even though I was not there when you're drafting the previous one, so let me give it a shot. So if I was sitting for this exam and I decided to draft this ruling, as usual, the format will be with the handing of the court, and then the parties. And then, of course, it will have the handing a ruling. So I would proceed to discuss the application before court by the applicant for review of the court's orders made on this date, on 25th December 2020, and I will describe the request. Then I would also now describe the respondent's case as well, how he is arguing his case and opposing the application, because of course the application is opposed. And then after those arguments, I would proceed to identify the issues that the court is supposed to determine. Once I identify the issues that the court will determine, then I will delve into them and the applicable law, and that is now be the analysis and determination. And I would here, for me, I would have identified what issue and the jurisdiction of the court, of course, to review its own orders. Then I would also probably discuss the application, the issue of whether the court, it's more of the same, really, jurisdiction of the court, whether the court can review or can grant the prayer sought to review the security downwards. That is whether there are reasonable, there are grounds, sufficient grounds for review of that application. And then after my analysis and determination, then I would come to grant the final orders of the court or the decision of the court, and then dated and signed, and the name of the JO and the place of delivering and the date. That would be the format I would adapt to draft the ruling. Back to you.
Okay, thank you so much, Njeru. I will repeat again, structure, there are also marks there, not just the content. How does the ruling, how is it supposed to look? Okay, so that is an issue that you really need to you really need to interrogate when you are drafting your ruling, including the captions and all those. So, and the good thing here, you need to know what that particular section provides and what is the law saying on that particular issue, especially, let's say, for example, on the matters review. What are these elements? By they have been provided clearly, both even under section 80 and equally under order 45. Okay, what are these? So those are some of the things when you are doing your analysis and you have an authority or two, you just throw it in there. So I will not delve much on this question in the sense that I cannot draft for you a ruling here, but it is something that you know by the even from just reading rulings and judgment, you can know how they flow. During our year, there was a ruling, and you have realized this was 2022. There was also a ruling. So we cannot actually say that there might not be a ruling in your paper this year, okay? Because especially for those last topic, execution, judgment, rulings, please just those that you think that they will not be told, and this and also proceeding before these specialized tribunals, okay? You have to give them a special consideration, okay? George Otieno.
I'm just requesting that you give us the structure since this is my first class to attend. I was not there. The structure of the ruling, how it should look.
Okay, it is almost similar or like the what Jiro gave. It is just like that. Okay, the sense that you'll have your caption, of course, the ruling, you'll have your introduction. Okay, you can give that particular background, like the case now. Okay, the case for the applicant, the case for the respondent. And in others, by they go to the extent that they give the submissions of the parties on those issues, the submissions that were made to those particular issues. So when you are done with that one, you now come for your issues for determination. Then after the issues for determination, so now you come now to your analysis of those issues, whereby now on every issue, a determination is going to be made on it. Then now you'll go and give your final orders. So you'll just note from most judgments and from most rulings, they differ just on that aspect of giving the background, or let's say the history of the case. Okay? Because they will give a case for this person, a case for this person. Others will go and give submissions on those particular positions that have been advanced, and then they will come now and give their issues for determination. So, and it is similar even with the judgment. It is this, just a similar approach. And the good thing about drafting rulings and drafting judgment, you will be relying on the facts that have been given in the fact sheet. Okay, you will not be inventing. However, now your understanding of the law will now become very, very significant when you will be drafting that ruling or that particular judgment. Is that okay, George Otieno?
Yes, thank you for that.
All right, you're welcome. So maybe our IT expert, former cyber attendant, so you can take us to question number 4. Or Rina? This is another good question, I believe. Atebe Mark, please read for us question 4. Atebe Mark.
Okay, am I audible?
Yes, you are.
Okay. The plaintiff filed a suit in the Commercial and Tax Division of High Court over a dispute with the defendant, who was the registered proprietor of property known as Kagu 4. The defendant was to develop 20 flats complete with all necessary access and infrastructure development, and that the proceeds from purchases were to pay for the construction of the flats. The plaintiff entered into an agreement to purchase 3 flats and paid for the cost of the land, part cost of construction of the flats. Consequently, the defendant transferred the property and the title was registered in the name of the plaintiff. The plaintiff alleges that he has paid the full amount as detailed in the sale agreement. The defendant has failed to carry out the construction as per the terms of the contract. The defendant filed a defense and raised a preliminary objection to the suit. The objection is based on the jurisdiction of the court, and it is the opinion of the defendant that the matter relates to land, and therefore only the Environment and Land Court has the sole jurisdiction to entertain the matter. Write an opinion on the directions the court is likely to give.
Okay, guys, this is another question that we are being requested. Not the correct word, but yes. Let us draft. Let us give that particular opinion. There's a PO that has been raised. Is this a matter that should be dealt with by the Environment and Land Court, or has it been properly filed in the appropriate forum? Let me hear what you all have to say, because this is something that is happening in real life. So guys, inueni mkono sasa. Ghana Zainab. You can unmute, you can proceed. Zainab. Okay. Madam President, your hand came first, then I will go to Were Jacob. Okay, Were, please go. Maybe
In
Madam
my
President has an issue with the mic.
Okay, first of all,
Yes.
I'm not quite certain how we are going to place the opinion, because is this an opinion where we do a memo? They've not said, they're not very categorical about it.
No, this one is just an opinion. You are just advising someone. I don't think this one we will use the format.
Okay. That aside,
Yeah.
if I check, the dispute in this case does not involve the utilization of land, but it involves contract, which is commercial in nature, because it is involving, first of all, there's the amount and there's the issue of specific performance according to this contract. So for me, I think, in my opinion, then the jurisdiction will be there and we will file it under commercial and tax division. So with that, then I will start with speaking about the issue of jurisdiction found under Mukisa Biscuits, and also the one found under Lillian S. Motovessel Lillian S. case. I think that direction I will take. I don't know. I'm not quite sure.
Okay. It is just that you have said something that jurisdiction under Mukisa Biscuit. I don't know if that is the correct position. Because Mukisa Biscuit provide for something else, though jurisdiction fall under it.
Yes.
Maybe you can correct yourself, Kidogo.
Mukisa Biscuit touches under jurisdiction. I think it also touches under PO.
So now, then the correct position is Mukisa Biscuit. It actually describes what entails a preliminary objection. Okay. Generally, such that how can a person raise a PO? Then now there are now those grounds under which someone can raise a PO. Then now jurisdiction comes in as one of them. Okay. But when you talk about jurisdiction, Lillian S case, then now you are in order. Is that okay? Bonawere?
Yes, it's fine. It's fine.
Yes, please. Okay. So Mukisa Biscuit describe what a PO is. Lillian S case, it is that decision has been affirmed, so it is now tried law. Even the Supreme Court, they rely on it. It touches on jurisdiction. What do happen? Yes, something like that. So let me hear Jura. Jura now. It is your turn. I have heard the position of Were, which is, I believe, correct. Yes, Jura?
Yeah, I think, yes, what I wanted to say, you've actually clarified. So for me, I would I would take the route of first determining whether the PO is merited. And in that instance, the Mukisa Biscuit case will be important. And secondly is the issue of jurisdiction and the fact that without it, the court then downs its tools. So those two parameters will be key in terms of making this particular ruling. And now going into the issue at hand, for me, I see it as a matter that involves agreement regarding purchase of property. So I think the Environment and Land Court has jurisdiction. Thank you.
Okay, thank you. Thank you for your contribution. Yeah, Barak.
Yeah, I'll concur with the speakers, Weary and Justus. Just to add, so the Lillian case will tell you that if no jurisdiction, the court downs its tools. But now, what is the test to be applied here to determine that the court has or does not have jurisdiction? I think that that is also important. So from Joel Ngugi, professor, he says he came up with the predominant purpose test in Susanna Cheng Butler against Red Hill Heights, that you have to look at the predominant purpose or the predominant matter that is coming. I think that is what Were was also talking about. So I would cite that to bring out the test that is important here, just to determine which court then has jurisdiction. So in my view also, I think the question of contracting, it's predominant for me. And so I would also look at it commercially. But the main point I wanted to bring is the predominant purpose test.
Okay, thank you for that contribution. That was a great one. Let me hear, was that Barak? I thought someone was
Yeah, this is Barak. Yeah, thank you.
Hillary. Yes. Hillary, proceed.
Okay, thank you. I just wanted to add on, to comment on the issue of jurisdiction with regards to this matter. And I want to go with what one of the speakers said, that this is a matter that should be filed at the Environment and Land Court Division. This because if as much as it's a contractual issue, as I say, as is from the facts, but it's a contractual issue. If you look at the substratum of that contractual issue, it's matters involving land and property. So in that case, if you look at section, if you look at section 13 of the Environment and Land Court Act, jurisdiction of the court, section 13, subsection 2, we'll see that C says that in exercise of its jurisdiction under Article 162B of the Constitution, the court shall have power to hear and determine disputes. So if you read Part D, disputes relating to public, private, and community land and contracts, choices in action, or other instruments granting any enforceable interests in land. And if you look at this issue, it's a contractual issue, but it's a contractual issue whose substratum goes to the heart of everything, property and land issue. So in this case, as a judge as a judge sitting in this matter, what will I say? Okay, the matter, the court down its tool in this issue because it does not have jurisdiction. And if you look at the jurisdiction that's provided for, under statute with regards to this matter, which is a contractual issue whose substratum lies in the heart of land and property matter. So High Court, the Commercial and Tax Division does not have jurisdiction to entertain this issue. Thank you.
Okay, thank you for your contribution. Do we have anyone else before maybe I give my position? I can see our members are leaving. We are now at 79. We are in question 4, 2 questions to go. We don't blame them. We have been here for a while. Yes, so guys, this one, it is something that has been litigated. I appreciate all your positions, but now it is a tricky one, and we really have to be careful. I don't have time to take this authority, but it is something that I would like you guys to look at after this particularly. Okay. So it is that who says the case of Susan Cheng Butler and 4 others versus Red Hill. Please type that particular citation. Okay, just type for the benefit of our members. Okay, it actually settled this issue, and the facts in this particular question, they were actually taken from from this particular decision, from this particular authority. Okay, please type the correct citation. Okay, so this particular case, the High Court has jurisdiction, that is Commercial and Tax Division. It is High Court. So when you are saying High Court, you are right. So you are right. So High Court has numerous divisions, but it is just High Court. Okay, we take that predominant test, the one that one of our speakers mentioned. It is called predominant purpose test. Okay, so you see this particular transaction, we don't deny that the substrum of it is as a result of a land transaction. But there are things that have not been disputed here. Okay, a consideration was paid. We all agree with that. Okay, and there is no dispute as regards to the consideration. The name, the property was actually transferred to the buyer. There is no dispute as to the transfer. Okay, so you look at the Professor Joel Goge, as he then was, he now sits at the Court of Appeal. Let me just read it to you verbatim in his conclusion now. Something like this. This was what he said. In my view, therefore, it appears clear that the parties intended that their contract involved two distinct parts. One for the sale of land and the other for the construction of town houses and ancillary infrastructure. It is also my finding, based on the above analysis, that the parties also intended the contract to be dynamic in nature, where the predominant purpose of the contract would change over the contractual period. While the contract was predominantly for sale of land at the inception, it evolved in its present contractual form to become one for construction of townhouses and ancillary infrastructure. It is finally my finding that the land acquisition price having been paid as it is undisputed from the pleadings, and the title of the properties having been registered in the name of the plaintiffs, there is no dispute as to the ownership of land. The only contest being whether there has been a breach of the construction contract between the parties, and if so, which party is in breach and what the consequences for the breach are. Consequently, it is my finding and holding that the dispute between the plaintiffs and defendant that is presented to court is a dispute that is not primarily about land. I therefore hold that this court has jurisdiction to hear the suit. Okay, so the example that you have been given right here, it is in a way like it was uplifted from that particular authority. I believe someone has already typed that the citation. Okay, so anything that will now relate to the contract, the High Court is going to have jurisdiction. Okay, but you use that predominant purpose test, such that if it is largely dealing about the ownership of land, okay, it is a contract, but the ownership of land is being questioned, it is in dispute, then it will go to the ELC. But if there is no issue about land, the ownership, the title, but it is maybe the aspect of the contract, maybe it's something that the landlord was to do, and they have failed to do that, then they have breached that particular contract. Therefore, the High Court will have jurisdiction. Okay? Do we have any question? I think that particular authority settled that question for. Any question, guys? Okay. So now, Orina, you can proceed to question number 5. We are almost done, guys. Few more questions. Our cyber attendant, yes. Thank you. Okay, someone to read. Someone to read, please. Okay, guys,
Question
I will
5.
send you the authority in the paper. Yes, please proceed. Someone is saying there's a Court of Appeal decision. Please send all those decisions to the group. Yes, proceed, please.
Okay, question 5. Chunga Mifugo Corporation is a state corporation established under the Ministry of Tourism Development. The relevant provision relating to the appointment of its company secretary reads that the board of directors of Chunga Mifugo shall appoint the company secretary in consultation with the cabinet secretary after a competitive process conducted by the body responsible for appointing public officers. John Wilson was appointed as the company secretary on 1st July 2016 for a period of 5 years. On 15th March 2021, he applied to the board for reappointment for a further period of 5 years. Sorry. The board considered his application, and by a letter dated 10th June 2021, he was reappointed for a further 5 years. On learning of the reappointment, Carson Bradley, a human rights activist, filed an application to the Employment and Labor Relations Court at Nairobi seeking leave to commence judicial review proceedings for an order of certiorari to quash the decision of the board contained in the letter dated 10th June 2021, among other prayers. The file was placed before the judge, who certified the application as urgent and fixed it for hearing on 16th September 2021. The application was argued, and on 21st September 2021, the judge delivered a judgment in the following terms. 1. The body responsible for the appointment of a company secretary of Chunga Mifugo Corporation is a board of directors, and thus John Wilson was reappointed within the law. 2. The board followed the laid down procedure in the reappointment of the company secretary. And 3. In the reappointment or renewal or the contract of the company secretary, the issue of competitive recruitment does not arise. The application is dismissed with the costs, and Carson Bradley wants to appeal against it. A. Write a concise legal opinion on the legal issues raised by the facts and the judgment, and B. Draw a memorandum of appeal.
That is a great question. Maybe the one who read the question, maybe you can tackle question number A, please. You have been asked to write a concise legal opinion on the legal issues. Mm-hmm.
Yes, someone can pick it up as I drink some water. Sorry.
Okay. So. Yes, colleagues. Yes, someone please take us through question number A. Hello, guys. Someone take us through question number A. The time is not on our side. We are left with less than 26 minutes. Tafadhali, mkono juu. Okay. No one in question A. What about question number B? We draw a memorandum of appeal. Anyone? Guys, we are in discussion. Okay. George and Jura. George, go first, please.
Okay, I'm looking at the marks that have been awarded in A, and they are asking for two aspects. One is the opinion, and the other one is judgment. So I'm just confused there. I think that is what is also confusing the members here.
Pardon, that they're asking for legal opinion and judgment. I think they're asking for the same thing. It is a legal opinion based on those facts and the judgment of the court, the issues that are raised. Can
I proceed?
Yes, please proceed.
Well, you'll excuse me because I've not gone through the facts properly, but I would want to highlight on maybe how the legal opinion, the general template of the legal opinion. So on the first part, I'll try to reiterate of this case, then come up with issues. And the main issue here would be whether the board followed proper procedures in appointing the company secretary. And try to reiterate the decision of the court. And in terms of upholding the appointment, upon which I make conclusion based on those particular orders the court gave. So basically that would be my approach to the legal opinion. So I'll just try to raise up issues that formed part of that judgment, or that I can deduce from the judgment, and try to reason it out in the eyes of the judge. Then when it comes to drawing the memorandum of appeal now, it is where now I will come up with the title, where I say Republic. I believe this is under Republic of Kenya, or depending on whatever jurisdiction that is provided here, the case number, the parties, then memorandum of appeal, in which case I say that the defendant wishes to appeal the decision of Judge XX dated this day on the following grounds. So I state the grounds and then pray for orders, then I close it. Thank you.
Sorry guys, I was muted. Donna is saying that her mic is not working, but according to her, there is one legal issue that is arising, and it is that of jurisdiction. He is seeking for a leave from ELRC, whereas the High Court, whereas it is the High Court that has the jurisdiction. That is according to Donna. Okay, thank you. Emily, Emily, please unmute.
I wanted to talk about the part B of the question, but the previous speaker has handled it quite well. But what I'd add is in the introduction, after the Republic of Kenya, we note it's the Court of Appeal. And now the case number, the parties you have been given in this case, the appellant will be Carson Bradley versus the State Corporation named. After that, we have an option of saying it's an appeal from which court and which judge and the date of the judgment. However, it is not compulsory because this information will be repeated. So after that, we now state the title of what you are drafting, that is the Memorandum of Appeal. And then continue as the previous speaker has said, list the grounds and the prayers, sign it off. Yes.
I am, however, interested in terms of grounds. What are these grounds?
When it comes to the grounds, if it were me, I would state it very generally and say the judge erred in law and facts by deciding what was decided. I've not read the question properly. Yeah.
Okay. Very good. And what is your view? You see, according to Donna, ELRC cannot give this particular order, that it should be the High Court. What is your position about that?
Having not read the question, let me pass.
Okay, thank you so much for your contribution. That was really, really nice. So, and anyone else, guys? Okay. Yeah, I understand maybe we did not read question number 5. I will give you the task such that we acquaint ourselves with the paper. Okay, because it is clear, straightforward. So, and by the way, last year we drafted a petition of appeal. That one was in, was it criminal litigation? I don't know what it will be in your, by then it is straightforward. So imagine you have 5 marks here, and maybe you have borrowed from somewhere another one. Okay. So guys, you have not read question number 5, so I will not talk much about it. I would have really liked us to engage on that. Okay. Please take us to question number 6. Orina. Please take us to question number 6. Sawa. Who is going to read for us this last question?
Let me read it.
Okay, proceed.
Mambo Limited obtained judgment against Nairobi City County Government in the sum of Kenya shillings 135,296,000. The company is aware that the Nairobi City County Government operates an account at Ushirika Bank Limited, which has a credit balance enough to satisfy the total sum. However, the company is not sure of the steps it may take to have the decretal sum paid under the circumstances. Thus, the company, the nature and scope of the application it can make under the circumstances, and its merits or otherwise. 10 marks.
All right. So Mambo Limited obtained judgment against Nairobi City County Government in the sum of 135,296,000 The company is aware that the Nairobi City Council government operates an account at Ushirika Bank Limited, which has a credit balance enough to satisfy the decretal sum. However, the company is not aware or is not sure of the steps to take to have the decretal sum paid under the circumstances. Advise the company the nature and the scope of the application it can make under the circumstances and its merits or otherwise. So guys, this is another good question, typically civil litigation. Can I please have someone to take us through this particular question? Yes, George?
Okay, based on the question talks about the ways of execution, and specifically, this is garnishee proceedings, attachment of debt under Order 23, if I'm not wrong.
Okay. Thank you for that, George. Let me hear Madam President.
I wanted to comment on the part of garnishee proceedings. I think we cannot we cannot issue governments with garnishee proceedings. I have quite forgotten the name of. Just let me just confirm and then I'll get back. I just wanted to correct that we can't use garnishee proceedings on the government, but there is a way that we are supposed to approach in an instance like this. Let me just confirm and get back. Thank
you. Thank you, Madam President. Odhiambo, I will have Mwangi Samuel, then you will come, then Were will come. This is actually a typical, and I told you last time when we met, on that aspect of execution, please, there's always a question there. All right? So proceed, Mwangi Samuel.
So, as Madam President has said, I think that we cannot go by garnishee proceedings against the government. So here we are going to
please move closer to your mic, Mwangi Samuel. We cannot hear you. You are not audible.
Can you hear me now?
Yes, we can hear you now.
Okay, so I was saying that in this case, I think that we'll approach the court and seek a certificate of satisfaction. And with the certificate of satisfaction, we'll serve it on the Attorney General, no, the county attorney. And then the accounting officer of the county will be responsible for paying us, for paying the decretal sum. And that's now under Section 21 of the Government Proceedings Act and Order 29, Rule 3 of the Civil Procedure Rules.
I like that. Okay. Odhiambo?
I think he has spoken my mind, and just to add on from those facts, as the previous speakers have said that we cannot attach the government property. This is a county government. Once the certificate of satisfaction has been issued to the Attorney General, to the county attorney, is then forwarded to the accounting office. I think here is the county secretary, I think.
CEC.
Is it the CEC of finance? Oh.
Yes.
Then I think he's supposed to work on it. But I think this question, we need to proceed further to explain what happens in the event that the CEC does not act on that certificate of satisfaction. Now that may be the default. Now what is the way forward? So,
And actually,
the
it
way
forms
forward-
part of the question, because you will not end there, you will go further. Let's say the government now, they don't want to pay. What is then the
Yes.
recourse? Okay. But let me see. Madam President, have you confirmed? I will now then call Were and Anyona.
Okay.
Yes, Madam President.
Yes, and the previous speakers have they've said what I'd forgotten, the certificate of satisfaction.
Okay, thank you. Were, then Anyona.
Yes. Based on what the other speakers have said, of course, it's you extract decree and then you apply for certificate of satisfaction. You serve it upon the AG. No, the county attorney in this case, and then the CEC finance. But now, if they don't pay within 60 days, I'm not quite sure about that timeline, but I think it's around 60 days, is when you make you make a judicial review application against the decision not to pay. Thank
you. Okay. Thank you. Anyona, Oscar.
Yes, thank you, Senior. So I'd like to agree with the previous speakers, except to disagree a bit with Mr. Were, and say that that certificate of satisfaction, before you serve it on the county attorney, it must state the amount of money that you're claiming from them. And without repeating what they said, if that office has refused to pay the money, then you're supposed to, within 3 months of the refusal to pay, apply for an order of mandamus to compel them to perform a public duty of paying you the money. Because even then, the money doesn't belong to them. So before you make that application for mandamus, you must seek leave of court first. So you make an application through ex parte chamber summons, supported by affidavit. And once leave has been granted to apply for mandamus, you then make that application within 21 days of that leave, and then you will serve on that officer 8 days before the date of hearing. So if that order of mandamus is given, and then they do not pay still, you'll request the court to issue them with a notice to show cause why they should not be committed to jail, civil jail for that matter, for failure of obeying the court order. That is what I have to add, Senior.
Okay. Thank you so much, Anyona. I believe we are at 9 out of 10. George Otieno, then Odhiambo, you will come after George.
Okay, I do agree with the previous speaker, the immediate previous speaker, but the question is where do you get this certificate of satisfaction order? You apply it to the deputy registrar. After you there you attach a copy of judgment, and in that decree you state the amount. Then after that, if you have obtained that order, that certificate, then you serve it to the county attorney. County attorney must endorse it, and it must be signed also by the judgment, the decree holder. It must be signed. That aspect, what I'm bringing is where do you get the certificate, and who are you supposed to serve? It must be endorsed before you serve it to the county officer in charge of finance. But the other process is okay.
Okay, that is a great one, a great observation. Odhiambo, Stephen?
This and is an old and. Nevertheless, I agree with the speakers. Just to add on that, or maybe if someone had stated it that in the event that now the county has refused to pay the decree holder, then the decree holder can now cite the accounting officer for that particular account, in this case, the CEC for Finance Nairobi County, for contempt of court. Maybe if someone had said, that is what I can add. Yeah.
Very good, very good. So guys, by the way, this question has been perfectly answered. For me, it is a 10 out of 10. It is just that you see, sometimes if you just say judicial review, you'll get a mark, but you will not get a mark like someone who has gone further to explain this particular application and what you are seeking for. You see, judicial review is general. There are several orders that you seek. But in this particular instance, whereby there is a default, or maybe the government or the county government has refused to pay, so what you are seeking for them now to be compelled to perform that particular public function. But they are much afraid. Government, by the way, they cannot pay you until now it becomes that now someone is going to jail. That is when they will. And if someone is actually compelled to perform that public duty, the money by the way is not theirs. Even you don't understand why do they refuse to pay in the first instance. Okay, I can see someone has provided an authority. So go further. Don't just mention judicial review, but tell us which this particular order that you will be seeking. So you remember, you cannot just execute against the government. It cannot happen. So there are other specialized instances whereby things, I don't know which one is that. Is it interpleader or it is what? I don't know. There are things about 3 or 4 instances whereby you don't just do anything about the government. You have to get some notice, information. I don't know. There is a specialized treatment for the government, and that is why you see you cannot just execute against them. So this question has been answered really well. Okay, and you have now witnessed. So just have your 10 marks in execution. Those topics that you will not be taught much, especially the last ones, please read them. Okay, so in this particular discussion, it is only question 5 that has not been done well because maybe you have not read it or you have not understood, but it is now a task that all of us, so that we can see what we'll do about that particular question. Okay, so guys, we are at the tail end of our discussion. Okay, I have completed my part. Okay, so my question then is to you guys. Maybe the floor is to all of you. If you have any question in that is related to something else, matters CLE, anything else, you can come forward. Then before we close our meeting with a word of prayer. So it is question time, guys. All right, there's no one. So guys, thank you for participating in our discussion today. It was really engaging. I really like that. Yes, who is that?
This is well. Sorry, I was trying to raise my hand, but it's refusing. I think it's thinking that the time is now done.
Yes.
Yes, I just had a small question, which is still disturbing. You said anytime they tell us to write an opinion and they're not categorical, then we can just write an opinion, because sometimes I think the nitty-gritties may matter, or maybe when they're silent, I just go through it the way I want. Huh?
Yes. So you see, unless if you are told, because here you see there are questions that we are told, you prepare or you draft a legal opinion. You will have to draft a legal opinion, but there are instances whereby you will have to advise someone, because there's place that you have to give an opinion. If someone is telling you to give an opinion on something, just proceed and give your opinion as per your understanding of the law. Okay? It won't change much. But if someone really wants you to draft a legal opinion, they will tell you, prepare or draft a legal opinion. Okay? Is that okay?
It's okay, thank you. It's okay, thank you.
All right. Okay. Jero, your hand was up.
Yes, thank you. I needed a little bit of clarification on question 1 on jurisdiction, but upon going through the question, I think I've seen why we went for the High Court and not the ELC.
Okay.
Yeah, thank you.
So you are satisfied. Okay, thank you. Thank you. Anyone else, guys? Sawa. So what I would say as my concluding remarks is to tell you guys this is something you can do, and it is something that is possible. Just don't stress yourself so much. Just plan your time accordingly. Okay. Mwangi Samuel.
Okay,
Your
so
hand is up.
I am not very, yes. I'm not very sure in regards to on 5, the question on the legal opinion, 5A. I'd seen that the person by the name Carson Bradley was a human rights activist, the one who had brought the judicial review proceedings. What I'm not sure about is whether that person had locus to bring the judicial review proceedings in consideration that likely was not affected by the decision.
Okay. That
So
is
I don't know.
interesting. That is an interesting observation, but Article 22 speaks a lot to that. And the case of Trusted Alliance Society, it has gone up to the Supreme Court. Is it Mumo Matemo, or is it called what? Something like that. So anyone right now, you can bring a suit on your behalf or on behalf of others. Okay?
Okay. Okay.
Yes.
I thought that only applied to constitutional petitions.
For constitutional petitions. No. I think right now, you see, even those who are incapacitated, like minors, someone has to bring a suit against them on their behalf. Yeah, indeed, it is with regards to constitutional petitions. But you see, this one is also public law. Okay, interesting one. It is. Let me see how I will respond to that. Okay.
Okay.
I will get
Thank
back to you on that. Yeah. Yeah.
Okay.
Guys, anyone else? Because I was about to give my wisdom. So that we can conclude. So it is like that, guys. Don't stress yourself about this thing. You only need to answer 2 questions or 3 ikienda sana. Okay. So unless if you want to be the best student, then you have to get it all, because people are getting 58, 59 out of 60. Very, very possible. Okay. So, but if you are the rest of us, we call ourselves others. Okay. Si ati mimi ni mbaya sana, but you just need to remove that distress. Okay. I'm really praying and rooting for you guys that you do well in your project work, because it will really cut your time in terms of how you will utilize, and maybe in time of studies. For us, we had a lot of time to prepare for CLE, but for you guys, I don't know, you only have like 2 weeks. Okay. So it means that you must be like studying like right now, you see? So, but it is something that can be done. Don't stress yourself, just do your best. Okay. Now utapita to CLE. Okay, just the way that you did your orals, your project work, This is also just an example. So that is it on my end. And thank you all. Unless if there is anyone else, then we will just close with the word of prayer. Okay. Jeru, you can pray for us, please. Or you prayed before?
No, is
Maybe
it
not.
Jeremy or
Jeru Alice? Or there was a Jeru that was who had a masculine voice. That must have been a man. Yes. Okay. Proceed then,
Jero
you
David.
are.
But I will seal the
Okay.
floor to Jero Anis. Thank you.
Okay. Masawa local man.
okay, let's pray. Dear Lord, we thank you for the wonderful discussion that we've had. We bless you for the wisdom, your knowledge, and your understanding, King of all glory. We pray that even as you continue preparing for our exams, O Lord, that you may continue being with us, providing with us all the understanding, the wisdom, and the knowledge that is required for us to pass our CLE. Be with us tonight, even as you are going to sleep. Protect us, guide and guide us, and when we see the day of tomorrow peacefully, remind us to thank you. We love you, God, and we honor you. It is in Jesus' name I do pray, trusting and believing in Jesus.
Amen.
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 Good
Amen.
night.
Thank you so much. Recordings will be shared. If you will have an issue accessing it, Daniel will do the necessary. Okay, so you will be sent the YouTube version of the recordings. Please don't lose your sleep. It will just like your first exam that you did in nursery. It will be really a small matter for that matter. Okay. Good night. Bye.
Wait.